In the year 1215, if you were accused of theft in England, your lawyer did not file a motion. A priest handed you a red-hot iron bar. You held it. You walked 9 steps. Then you waited 3 days. If the burn had healed cleanly, you were innocent. If it had festered, you were guilty. God, apparently, had communicated his verdict through your tissue damage. This was the legal system. The history of law is not the history of justice. It is the history of power deciding what justice looks like. For most of human civilization, there were no lawyers. There were only rulers, priests, and the accused. The Code of Hammurabi, written around 1754 BCE in Babylon, is one of the earliest known legal texts. It contained 282 laws. It also prescribed death for approximately 25 different offenses. There was no right to appeal. Ancient Rome came closer. Roman citizens could speak in court on behalf of others. These men were called advocati. But there was a problem. Roman law explicitly prohibited them from being paid. Advocacy was supposed to be a civic duty, not a profession. They were paid anyway. In 204 BCE, the Lex Cincia attempted to ban payments to advocates entirely. Advocates found creative workarounds. The law was largely ignored. Some things about lawyers have remained constant after the fall of Rome. Legal advocacy largely collapsed in Western Europe. What replaced it was something far more primitive. Trial by ordeal. Trial by ordeal operated on a simple theological premise. God is omniscient. God will intervene. Therefore, the outcome of a physical test reveals divine judgment. The most common ordeals were fire, cold water, and the consecrated morsel. In the ordeal of cold water, the accused was thrown into a river. Sinking meant innocence. Your body had accepted God's water. Floating meant guilt. Surviving was not always part of the plan. The profession of law did not re-emerge from a moment of enlightenment. It re-emerged from monks. During the 11th and 12th centuries, scholars in Italian monasteries began rediscovering and studying Justinian's Corpus Juris Civilis, the great codification of Roman law. Compiled in 529 AD, the University of Bologna, founded around 1088, became the first institution to formally teach law. Students traveled from across Europe to study it. For the first time in centuries, there was a curriculum. There was a discipline. There was something approaching a profession. In 1292, King Edward I issued an order requiring common pleas courts to select and train a certain number of attorneys. This is considered one of the earliest state-organized attempts to create a formal legal profession in England. It was regulation. Barely. The distinction between a barrister and a solicitor, which still defines the English legal system today, began forming in this period. Barristers argued cases in court. Solicitors handled paperwork and client preparation. The division was not philosophical. It was territorial. Different guilds controlled different parts of the work. The single greatest turning point in the history of Western law came not from a lawyer, but from a pope. In 1215, the Fourth Lateran Council, convened by Pope Innocent III, officially banned clergy from participating in trials by ordeal. Without priests, ordeal had no ritual legitimacy. Almost overnight, courts across England needed a replacement. What emerged was the jury. 12 ordinary citizens, drawn from the community, asked to determine the facts. Not God. Not fire. Not water. People. This was a profound conceptual shift. Now lawyers had something to do. If facts had to be established through witnesses, questioning, and argument, suddenly, the ability to speak persuasively and reason logically had practical value in court. The abolition of ordeal created the adversarial trial. The adversarial trial created the lawyer. By the 15th and 16th centuries in England, the Inns of Court had become established institutions for legal training. Gray's Inn, Lincoln's Inn, the Inner Temple, the Middle Temple. These were not just schools. They were guilds. social clubs, and gatekeepers, all at once, in the American colonies. The legal profession developed under different pressures. Early colonial courts were informal. Many judges had no legal training at all. By the late 1700s, as the colonies moved toward independence, a structured legal profession had become a political necessity. The founders were, overwhelmingly, lawyers. Harvard Law School was founded in 1817. It began with one professor and 18 students. The formalization of legal education. The idea that a lawyer required structured academic training, not merely apprenticeship, was a 19th century development. Before that, you simply read the law under an established attorney and hoped for the best. Abraham Lincoln, for context, taught himself law by borrowing a copy of Blackstone's Commentaries on the Laws of England and reading it by firelight. He passed the Illinois bar in 1836. There was no law school exam. An oral interview with a judge was sufficient. He later became President of the United States. Today, becoming a licensed attorney in the United States requires an undergraduate degree, 3 years of law school, and passing a bar examination. The process takes, on average, 7 years. It costs, on average, over $200,000 in tuition. In 1215, it cost you a burned hand. The system has grown more sophisticated, more procedural, more expensive. Whether it has grown more just, that question, much like the outcome of a 13th century ordeal, depends entirely on who is asking and how much they can afford to pay. In the next episode, we examine another profession built on centuries of confident ignorance. The doctor, a man who, for most of recorded history, believed that illness was caused by an imbalance of invisible fluids, and treated it by removing your blood, on purpose, with enthusiasm,